I'm Mark Reel, and I'm coming to you live from Lake Placid, Florida today, a little pre-Christmas trip. And we have a guest joining us. He's going to be our first 3-time guest. I think you were our first 2-time guest. And he's got a lot of exciting things going on that I know a lot of people want updates for. So our guest today, we're a little bit early this afternoon, is Minnesota Attorney Ryan McLaughlin. Ryan, how are we doing today?
Mark, thanks for having me back. It's always a good conversation. I know you have your, every week you get to have these conversations, and it's always a pleasure to kind of pick your brain and put this information out there. So, the two prior times we focused a lot on the Constitution for folks in family court who want to see their kids more. And we focus on the Constitution, right? Because it's a weapon that's never used, and it's a weapon that it's the highest court in the land, right? The U.S. Supreme Court, yeah. The Constitution. And so from New Jersey to Washington State, Oregon, right? All this, every single state, if you make a U.S. Constitution argument, you win. And you don't see those, right? Local attorneys don't see those. You don't see people litigating. I have a federal constitutional right to see my kids. And so a lot of that's been what I've been working on and what we've talked about already and ground we've covered. Today, I kind of have a couple more angles on that same idea. Nothing new, but a couple more, a few updates that I wanted to talk to you about. And, I wanted to start with just sharing kind of boots on the ground update from life in Minnesota, life in COVID. So there's a case I'm aware of, a client I'm representing who's facing going to jail in early January for not paying enough support monies. Right. So he pays support, he pays child support, and he pays spousal support. But the court has said, you're in contempt of court, and you either purge your arrears and pay up or see ya, right? You're going to jail. And
yeah.
And I raised this for a couple of reasons. One, this is serious, right? This is you're going to jail. And they say that it's not a punishment that we're putting you in jail. It's to help you, it's to encourage you to pay, right? But like, how are you going to pay when you're in jail, right? I mean, under what logic, right?
Are they going to give you a job and you're going to pay using that $1.38 or whatever they pay you when you're in prison working a job? Like, what are we doing?
Yeah, right. So that's one, right? And we laugh, but it would be terrifying if this was me. If I was in this position.
Well, think about this. Let's think about this. And this is something I'm sure you see. COVID impacted so many people financially. And there are so many people that have arrears that are well-meaning, that made all of their payments and then lost their jobs. And maybe they didn't go out right away and get that modification. And I know out here in California, we're just starting back up enforcements. So what are those enforcements going to look like? Are we going to start taking people's licenses in bulk? Are we going to start locking people up in jail because a pandemic took their livelihood away from them? It's going to be an interesting question. And I mean, I think it ties into the constitutionality. I mean, these were government mandated shutdowns that cost people this money, that cost people these jobs. And now the government a different arm of the government wants to come around and punish them for that.
Yeah. And the thing I'll say is, I'm a lawyer, but a lot of my work is done by my clients, right? So if you're watching this, if you're a mom or dad, whatever, you have an incredible amount of power to pay attention to stuff, right? So for instance, if the court's saying that your arrears are $100,000, maybe they are, but in many of my clients' cases, they're not, right? The court is understaffed, overworked, and right, they're and this is true with a lot of government entities. So because it's your case, your life, your bank account, your payments, better than them. You just don't have the power. So
better than your attorney, and you need to realize that.
100%, 100%.
I tell all my clients, here's the deal. My job is strategy. My job is to put you in the best position possible. But there is no possible way, even if I spent 80 hours a week on your case, that I even have a fraction of the knowledge and understanding of what's going on in your day to day life. There's a lot of pattern stuff that, I mean, I know you see it too, Ryan, that's like this situation's occurred. So we know that this is the strategic move we need to make, but each situation's different. And I think that's the big thing I always tell dads is you got to take ownership in your situation, because I'm only as good as the information I'm given,
Yeah.
and you have to own the facts in your case.
Yeah. So the tool here would be right first, double, triple check whatever the court's saying or doing. Double, triple check the court order. And I mean
In
this in,
most states, you can request an audit. You can go to child support and say I want my case audited, and most states have a time frame in which they must audit your specific case.
right. So that's number one, right? Make sure if you're the petitioner in a case and the respondent just won based on their version of the facts, make sure that whoever the opposing party is, make sure that their facts match up with the county audit, right? With what the county has on record, and then make sure that that's actually what you paid. Because sometimes you pay via check, or I don't know how you pay support, and it doesn't get counted, or it gets claimed as this when it's supposed to be that. Make sure the facts are right, because the court, I think, both doesn't care as much as you and isn't equipped to handle the kind of volume it's seeing, right? So they're just you know they're drowning, right? They're drowning.
Yeah.
And so you have to care. That's number one. Number two is for the attorneys out there. So that's for the litigants, for the clients. Number two for the attorneys is we're also inundated, right? We're also trying to help all these clients, this, that, and the other. But I think it's important too, and this is something that I have to do as well. Read the orders super, super carefully, right? Because if the court doesn't make findings of fact, if it gets the facts wrong, if it gets the law wrong, right? This is something to bring up, and it's something to hold like a torch to the court's feet and be like, your one job, judge, is to get the law right, and you get the law wrong. And it makes sense. These judges are shuffled around from family court to civil court to criminal court. They're not getting paid oftentimes as much as attorneys. So mistakes happen. They misstate the law, and when you catch it, it's a time to make a big to torch it, right? To say, we got a huge problem here, judge.
And this is something I think the internet, I think you make a really good point. And I think the internet, I think Facebook as kind of a melting pot of dads and parents coming together, is we're seeing more and more often judges either going outside of the scope of their duties, or doing things kind of rogue on their own. I talked to a colleague of ours that a fellow attorney who is in Illinois, and there's people in hot water because they recorded court proceedings and then caught the transcripts being incorrect, and they were able to, with video, go in and say the transcript is incorrect, that's not what happened, and then they try to punish them. But it was a big deal with their child custody case.
Yeah. So the attorneys need to pay attention. The attorneys need to be proactive. The attorneys need to, and that's a general statement, right? What I'm specifically talking about is, right, every what did you say, Mark? Yeah, so the transcripts can be messed up versus what's actually being said. That's one example. But even case law, right? So in Minnesota, there's case law for everything, no matter what state you're in. There's the best interest standard has case law, case law for every situation. In the situation that I'm talking about, will throw you in jail. That situation will throw you in jail for not paying your child support. In Minnesota, there's a case that it's called the Mahadi case, right? This case says, this is how we're going to throw you in jail. This is what your rights are. You get this hearing to determine how much you owe. You get this hearing to determine if you can pay it. Then you get this hearing to say at the very end, please don't throw me in jail because of X. And that's a right. Like a R, like capital R, that's a right. You get it no matter what. It's not, you didn't show up. It's not, we didn't like you. You have to have that hearing. And the court messed that up, right? The court didn't read that that line of the case, which it's a real important line, right? It's just not super important for the court, but it's real important if you're a dad or a mom who's potentially going to jail in January for not paying money. Like, you have a right to this hearing. And so the question is, if you're an attorney, what do you do about that? And the only thing that I found as you can't often correct the judge. That doesn't go super well, right? It doesn't go over real well to tell the judge, Your Honor, you made a mistake here. Because probably, right, there's an adversary. So what I found is find colleagues, right? Find as many colleagues as you can. Find as many senior attorneys as you can. Find as many senior county attorneys as you can who are of that inside position, who have more seniority than the judge. And then just, but just throwing mud back at the judge, I don't find to be super effective, right? I feel like so that's
not in the micro, at least. Not in that person who's in front of the judge's case right then and there.
Right, exactly. So two things. One, people should pay attention to the facts to make sure the court gets the facts right. And this is specifically the clients, not the attorneys, because the attorneys don't know the facts. The attorneys should be looking at those cases and double, triple checking the judge's order. Oftentimes the attorneys just skim, right? We'll skim to the good stuff, the bottom of the order where it says granted, denied, granted, denied, granted. But we miss, the whole thing could be, the whole order could be flawed if the judge doesn't have findings of fact and conclusions of law, or if they mess up either. Which is a long-winded way of saying attorneys also slow down, right? You could be lethal if you slow down. And so I'm as guilty of that as anybody, right? So it's a good lesson for me. It's something I've been focusing on, and it's happened right now. And I think anybody in family court can help their attorney slow down. Just they could read the orders themselves, right? So that's one thing.